changes. We are back on the record in the matter of the people of the state of Michigan versus Tora Nicole Trammell. Mr. Malaro, how would you like to proceed today?
Judge, based on our bench conference, I'd ask if we could have perhaps a 2-week adjournment so I could speak to Ms. Trammell and see if this can be resolved at that time.
Make my note. Okay, so I will set this over to May 15 pretrial at 8:30 in the morning. So Ms. Trammell, you'll need to zoom back in on May 15 at 8:30 in the morning. And it's also very important that you get a hold of Mr. Malaro before that court date, okay?
Okay, thank you.
All right, thank you.
Thank you.
Bye-bye.
Bye-bye. All right, I have a gentleman at the jail in room number 1. What is your name, please?
Jeremy Sneed.
All right, let me grab your file. Miss Underwood, I have asked the jail for everybody, so. Okay, this is in the matter of the people of the state of Michigan versus Jeremy Sneed. I have file number 23-21384FH. I have Salvatore Malaro appearing on behalf of Mr. Sneed, and I have Phoebe McClure appearing on behalf. Should be Mr. McCready. Well, I don't have them. Phoebe McClure appearing on behalf of the people. This is a date and time set for pretrial. Mr. Malaro, how would you like to proceed?
Your Honor, I believe we have a resolution on this case. Resolution.
Okay, so hold on a second. Ms. McClure is going to go into the system and see if she can get that information. So let's see. So what, Mr. Malaro, is the plea offer?
The resolution, Your Honor, is that Mr. Sneed is going to enter a plea of no contest to assault with intent to commit CSC second with a habitual third supplement. There is going to be a Killebrew agreement adds to the sentence of 28 months with a 120 months tail. That I believe is our plea agreement.
All right, so Ms. McClure is looking that up. I will say that I have not received an amended information. So it looks like that would be an added count 2.
Yeah, I just texted that to Ms. McClure, Your Honor.
Yes, and I just received a text as well that Mr. McCready's hopping over from Judge Olsaber.
Okay. Let's get him over here.
Judge,
Yes, ma'am.
there is also a VOB pretrial scheduled on his jury trial date. I don't know if you want to add that today.
Okay, Mr. Malaro, there is a BOP as well.
Correct. We understand.
Is he going to be pleading to the violation of probation then?
Yes.
Miss Adams, could you just print off on my printer number 9, the VOP, or bring it to me?
Yes.
All right, so Mr. McCready is now here for the Sneed matter. So Mr. McCready, Mr. Malaro placed the plea agreement on the record that he's going to be pleading to an amended information with an added count 2 assault with intent to commit criminal sexual conduct 2nd degree. What is the maximum penalty on that offense, please?
5 years.
And then it also requires SORA registration.
Correct.
Okay. And with a Killebrew agreement that the sentence would be 28 to 120 months. Is that correct, Mr. McCready?
Yes.
Excellent. All right. So
There's
Mr.
also-
Sneed. Oh, go ahead.
Judge, Your Honor, there's also the habitual third supplement, which will be on there also, which makes it a 10-year offense rather than a 5-year.
All right, so Mr. Malaro, is that correct?
That is correct, Judge.
All right, so it would be a second or subsequent offense, making it a 10-year felony.
Third, actually, it's a habitual third.
Oh, well, he has a second offense notice and he has a habitual third. There's two of them on the felony information.
Right, but I think the second, let me just pull this up here.
Because the second offense requires a mandatory minimum of 5 years, so I assume you're getting rid of that one.
That is correct.
Okay, and then he's gonna be pleading as a habitual offender, third offense notice,
Exactly.
but that makes this offense life.
Well, so it's because it goes down to a 5-year, then the third doubles that to make it a 10-year.
Okay, okay. Is that correct, Mr. Malaro?
Yes, that's our agreement, Judge.
And that's
Okay,
where the
so
120 months comes from.
Okay,
At the
okay,
top.
so a 10-year. All right, okay. So, all right, so he's gonna be pleading to an amended information to count 2, assault with intent to commit, assault with intent to commit criminal sexual conduct, second degree, which is a 5-year felony. And he's going to be, the second offense notice will be dismissed, so there's no mandatory 5-year, but he'll be pleading to a third offense, which would double it. And so the maximum penalty would be up to 10. So the maximum, 10 years. And there's no agreement regarding anything else. Is that correct, Mr. Malaro?
Well, the agreement is the minimum is going to be 28 months, Judge.
Yep, I did. Yep, 28 to 120. Okay, anything other than that, Mr. Malaro?
No, Your Honor.
And then Mr. McCready, the fourth offense, so he'd only be pleading to that, but not the third offense, but not the fourth offense. So
We
one
have
of them will be dismissed.
Right, we have an amended information prepared and it just lists habitual third.
Okay. All right, so Mr. Sneed, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So Mr. Sneed, can you state your full name for the record for me?
Jeremy Allen Sneed.
All right, so Mr. Sneed, you've heard that long discussion between the prosecutor, the defense attorney, and myself. So is it your intention to plead guilty to an added count 2, which is assault with intent to commit criminal sexual conduct, second degree, with which the third offense notice would make the maximum penalty up to 10 years in prison, with a Killebrew agreement that your sentence would be 28 months to 120 months with the Michigan Department of Corrections. So do you understand that plea offer?
Yes, ma'am.
Is it your intention then to plead guilty to that offense?
Judge, it's no contest.
Or, I'm sorry, I missed that. So it's
And the
no
base-
contest.
The basis is lack of memory.
Okay, so you're gonna plead no contest to that offense, Mr. Steen?
Yes, ma'am.
Are you satisfied with your attorney and the advice that he's given you?
Yes, ma'am.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Mr. McCready?
I agree.
And is that your understanding as well, Mr. Steen?
Yes, ma'am. I just had a couple of questions. I didn't know
Sure.
about my probation, how that was gonna be involved with this. Just
So you have a probation violation out there. So I was going to talk about that in a minute. But you have a request and warrant for probation violation from last year that's been kind of tailing along with this new charge, right?
yeah.
The violation of probation is that you were arrested on a new felony warrant for criminal sexual conduct. So you can plea on that today, or we can set that to another day.
I would, if it were run concurrent, I would plea on it.
Well, it probably, you're on probation for domestic violence. So you're probably looking at a jail term on that. And right, Chris, I think it's a domestic violence third offense, so it's a 5-year. I don't know what his guidelines were on that.
The guidelines on that probation violation were 0 to 9.
Yeah, so you'd be looking at either revoke and terminate probation on that, county jail term, revoke and terminate, but it would run together with any prison term that you're serving.
I would plead today guilty on that.
Okay.
And the only other question I had to ask you that they said that I had to ask you specifically was for my state for cause last time I went to the MDOC, they was taking everything over $10 in my account. So I was gonna ask you if you could suspend my state restitution so I can live, because I can't live off of $10 a month in there until I get out.
So on your probation term and on the new file, so on your probation, you have your fines and costs on that one at $68 and $130. I don't think there was restitution on the probation one. Is there, Mr. Jones?
I don't believe so, Judge, but I need to make a correction. I had the wrong PSI in the file. I'm looking at his current one now from the probation violation. His guidelines were 10 to 23.
Well, you're still looking at a county jail term.
Yeah,
So,
I mean, that's what I was gonna say. So with the new
and that's on file number 2021-20208FH. So, Mr. Sneed, on your new file, because you're going to MDOC, you're gonna owe $68 and $120. And that's crime victim rights fee and state costs. And that'll be on your probation one too. I can't suspend that.
That was the from the times before is when I got it. When I went to prison the first time when I was like 17 or 18, you know, I got into a whole bunch of trouble and with state property and stuff, and that's why they were taking all that money from me.
So I think, yeah, that was restitution. And Mr. Jones, I don't think there's any way I can suspend, if I'm revoking and terminating probation. I mean, I can do something on the probation one, but I can't suspend payment of that while he's incarcerated. Can I, Mr. Jones?
I don't believe so, Judge, but he doesn't owe any restitution on his probation.
Yeah, you don't have any restitution on these files, so there won't be a restitution order, but there is that 68 and 130, okay?
Yeah.
And if you have a family member that'll come and pay those, that takes care of it for you, all right?
Okay.
And if they pay it at the courthouse, then it's taken care of and you don't have to worry about it. All right, so, okay, and your rights are gonna apply both to your probation violation and to this. So, if a guilty plea or if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. Who do I have in jail Zoom number 2? Gentleman with the beard?
Daniels.
And what is your attorney's name?
It's
Murphy. That's
All
my
right,
client.
Mr. Murphy, do you need a breakout room with Mr. Daniels?
If I could, please, Your Honor.
All right, and I would just say you guys stay in the breakout, or Mr. Daniels, you're just gonna stay in the breakout room until I bring you back, all right?
All right.
So I'm gonna put Mr. Murphy and Mr. Daniels into the breakout room. Okay. Ms. Wagner and Mr. Mallow don't join the breakout room. Okay. Okay, so, Mr. Sneed, so, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence other than the agreement on the record. Is that correct, Mr. Malaro?
That is correct, Judge.
Mr. McCready?
Correct.
And Mr. Sneed, is that correct as far as you're aware?
Yes, ma'am.
So you're gonna be pleading guilty on the violation of probation. And then you're gonna plead no contest on the new file. So you understand if those pleas are accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that were that would otherwise be available if you were convicted at trial? Do you understand that, Mr. Sneed?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that by entering the plea to the new offense, you may be required to register under the Michigan Sex Offender Registration Act? Do you understand that?
Yes, ma'am.
Okay, so I'm going to start first with the new file. How do you plead to the charge that on or about, remember, you're going to be pleading no contest or no, not guilty. So how do you plead to the charge that on or about August 12 of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense of assault with intent to commit criminal sexual conduct second degree? No contest or not guilty?
No contest.
And then on file number 21-20208FH, how do you plead to the violation of probation that you violated the articles of your probation dated April 1 of 2021, and that you were arrested on a new felony warrant for criminal sexual conduct on May 18th of 23? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to plead no contest and no, not guilty on these charges, other than what was placed on the record?
No. No, ma'am.
Okay, do you understand that if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty and no contest? Mr. Malaro?
No, Your Honor.
Mr. McCready?
No, Your Honor.
So, Mr. Sneed, you've pretty much been laid out what your sentence is going to be in advance, but has anyone promised you anything else other than the agreement that was placed on the record?
No, no, ma'am. I just didn't know if I still, do I get my time credit for being in jail? Or
If you're in jail on the CSE, yeah, you're gonna get credit for that. But yeah, we'll give you credit.
Okay.
All right. Is it your own choice to plead no contest on file number 23-21384FH?
Yes, ma'am.
Is it your choice to plead guilty on file number 21-20208FH for the violation of probation?
Yes, ma'am.
All right, so I'm gonna start with the violation of probation. So on file number 21-20208FH, Mr. Sneed, you are on probation with Christopher Jones, is that correct?
Yes, ma'am.
And one of the terms to your probation is you're not to commit any new criminal offenses. And were you charged on April 1, or no, were you charged with a new felony warrant for criminal sexual conduct on May 18th of 23?
Yes, ma'am.
And in fact, you're pleading no contest to that charge today.
Yes, ma'am.
Okay, so let's go back to file number 23-21384FH. So he is pleading no contest on that. So Mr. McCready, can you place a factual basis on the record?
Yeah, I had a couple of thoughts on that. There was a preliminary exam. We could
You
incorporate.
can use a transcript.
I would like to do that, yes.
Okay. Well, I don't have it, so you gotta put it on the
Oh.
record.
Okay, well, I could also.
Yeah, I have
read
it, but I haven't read it.
You know,
the- Understand.
you want me to do it? I got it. I have it.
Thank you, Mr. Morrow.
You guys
All right, go
ready?
ahead, Mr. Malaro.
Tell me when you're ready. So Judge.
I'm ready.
All right, so Your Honor, we believe that the people would show beyond a reasonable doubt that on or about August 12th of 2022 in the city of Adrian, Lenawee County, that Mr. Sneed did in fact commit the offense of assault with intent to commit CSC second by he was at his brother's house for the night. He laid down with his daughter. I think she was 10 years old at the time.
Make sure you use initials. Thank you.
Yep. I think it was initial CS.
CV.
And while they were laying on the floor sleeping, the testimony at the preliminary exam was that Mr. Sneed did cup his daughter's breasts and massage them by her description at the preliminary exam. I think that would constitute an assault with intent to commit CSC second. And Mr. Sneed has two, let me look here, or three, has a conviction for an R&O in January of 2006, a attempted fleeing a police officer in 2006, and a possession of less than 25 grams of a controlled substance in May of 2022.
That's none of mine. That's none of mine.
Oh, Mr. Malaro,
Oh.
I'll ask him about his subs. That's fine.
I'm sorry,
I can do
Judge, I'm
that.
looking at the wrong one, sorry.
Yeah, no. So Mr. Sneed, you were convicted on, let me see here, on July 13th of 2004 of larceny in a building in Lenawee County 39th Circuit Court. Is that correct?
Yes, ma'am.
And then you were convicted on October 14 of 2005 of criminal sexual conduct second degree. Is that correct?
I thought it was third. I'm not sure.
Okay, so we can use another one. How about home invasion second degree back on September 14th of 2014 in Wayne County?
Yes, ma'am.
Okay, are you satisfied, Mr. McCready, with the two subs for the third?
Yes, Your Honor.
Are you satisfied with the factual basis placed on the record by Mr. Malaro?
Yes, I am.
All right, so based on the facts placed on the record and from the information contained in the transcript from the preliminary examination, the court finds beyond a reasonable doubt that on or about August 12 of 2022 in the city of Adrian in the county of Lenawee that the defendant did commit the offense of assault with intent to commit criminal sexual conduct second degree by being over the age of 17 and engaging in sexual contact with a person under the age of 13. They had testimony from the preliminary exam supports that they did lay down in a bed and he cupped the minor's breast, who was, I believe, a stepchild. Is that correct, Mr. Malaro?
It was a daughter, Your Honor.
A daughter.
It was not a
And
stepchild.
okay, does that satisfy the sexual contact, Mr. McCready?
Yes, it does.
All right, has the court, and therefore the court will accept the no contest plea based on lack of memory. So Mr. Malaro and Mr. McCready, has the court complied with the MCR 6.302 B, C, and D? Mr. Malaro,
I believe it is.
Mr. McCready?
Yes, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There is a Killebrew agreement that's been put in place, as well as a Cobb's discussion regarding the violation of probation. I'm going to refer this matter to the probation department for a pre-sentence investigation. And we will set this matter for sentencing on May 30th at 8:15 in the morning. Now, Mr. Sneed, you have the right to be present in person for sentencing, or you can appear via Zoom. That is your choice. So would you like to appear in person or via Zoom?
Zoom.
All right, so we'll set that via Zoom. So Mr. Jones will be over to meet with you and have to fill out a packet. He'll do a pre-sentence report on the new charge. He'll do an updated probation violation report on your violation. And then we will provide a copy of that to Mr. Malaro. He will review that with you before sentencing, and then we will see you back here May 30th at 8:15 via Zoom. Is there anything else? Mr. Sneed, understand you pled no contest on the new charge. So you do not have to give a statement about the events that occurred. So you would only give information on your background on that case, okay?
Okay.
All right, and be truthful with them about that. We'll see you back on May 30th at 8:15 for both the VOP and the underlying file.
Judge, you said May 30th?
I'm sorry, May 30th at 8:15.
Okay.
Okay, thank you. Anything else, Mr. McCready or Mr. Malaro?
No, Your Honor.
Okay, thank you. I know every county does it different, Mr. McCready, so.
Exactly. Yeah, thank you.
Okay, but most of the time we don't have a copy of the police report, so that's why we just went to that
Got it.
procedure. All right,
Okay.
Mr. Sneed, you are all set, okay?
Thank you.
Brenda, I'm gonna call the jail again. No, see Mr. Sneed. What's a breakout room? Hey, this is Judge Anselm again. So, we got Mr. Sneed. So I am ready for Ernest Jasper, Mr. Cordova, Mr. Williams, Mr. Daniels, and
Mr. Williams, wasn't it?
well, I did Sneed, and I have a gentleman with the beard. What's your name again?
Daniels.
I have Mr. Daniels. I don't think I've done Xavier Williams. Have we, Miss Underwood or Miss Page? Yeah.
Judge, he is not on the docket for today. I sent them paperwork.
Oh, okay. So we don't need Xavier Williams. So just Ernest Jasper, Mr. Johnson. I think that's it.
In Cordova?
And Cordova. Yep, Cordova.
And
Oh,
Regulus.
sorry about that. Thanks.
No
Bye.
And
Judge, do you have a
Regulus.
Troy Johnson as well?
Do we have Kyle Raglis or Elizabeth Warner?
Okay, everybody stop. So on my jail list, Cal Raglis is a pickup. I haven't gotten there yet. I haven't done my pickups. I have Mr. Daniels. We have Ernest Jasper. We have Araldo Cordova. We have Tyler Daniels and Troy Johnson. So that's all the jail people I'm waiting on. Is there anybody I didn't mention?
No. And then I have a arraignment on a Gant.
Yeah, but he's not. Yep, we do. So in the matter of people of the state of Michigan versus Sherrod Rashawn Gant, file number 2024-21791FH. I have Salvatore Malaro appearing on behalf of Mr. Gant, and I have Amanda Wagner. You're my only prosecutor appearing on behalf of the people. Mr. Gant has neither zoomed in or come in person. Mr. Malaro, how would you like to proceed?
Here's how I'd like to do, Judge. So Mr. Gant waived his preliminary exam. His mother and his grandmother were present. They're very involved in this case. He's a young man. I did get a message earlier in the week or late last week that the mother spent all her money on the tether, and so all her utilities are being shut off. When I tried to call her back, her phone was out of service. I would ask for the grace of adjourning this 1 week for me to get them so we can get them back in right track because HIDA is a consideration here. I am
So I'm going to adjourn this to April 24 at 8:15 in the morning, and you just get them in then, all right?
Yes, Your Honor. Thank you very much.
All right, thank you. All right, so I have a gentleman in jail Zoom room number 1. What's your name?
Troy Johnson, ma'am.
Troy Johnson. Okay, so hold on one second. We'll be right with you. All right, Mr. All right, in the matter of the people of the state of Michigan versus Tyler Gregory Daniels, file number 24-21727FH. I'm Matt Murphy appearing on behalf of Mr. Daniels, and I have Amanda Wagner appearing on behalf of the people. This is the date and time set for a pretrial in this matter. I do see that the people have filed, or no, there was a notice of intent to use technician's report in lieu of testimony, and objection was filed against that. I don't think that's here for today, but Mr. Murphy, how do you wish to proceed today on the pretrial?
Your Honor, from my understanding, Ms. Wagner is offering for Mr. Daniels to plead to an attempted tampering with evidence and 1 count of R&O. The remaining counts will be dismissed. So if that is correct, Mr. Daniels does want to accept that offer and plead to that today.
Okay, so hold on a second. Ms. Adams is getting her work done today because we've had like plea after plea. So I do have a felony information, count 1, 2, 3. So will it be an added count 4, attempted tampering with evidence? Is that what you said?
Yes, Judge, I'm working on that right now.
Okay, and the maximum penalty on that is up to 2 years in prison?
Yes, correct.
Yes.
And is there any sentencing Killebrew agreement?
Your Honor, we are going to ask for, and I believe that Ms. Wagner is agreeing to a PR bond. There is no further agreement for sentencing or anything in the plea.
All right, so he'll be released on a PR bond today, Ms. Wagner?
That's true, Judge. I just wanted to ensure that there were drug conditions in place first. And I also wanted to add, as far as the plea offer, that part of the agreement too was that the people would not be issuing drug charges based on the lab reports that were received back.
Okay, do you understand that, Mr. Daniels?
Yes, I do.
All right, so, and is that correct, Mr. Murphy?
Yes, Your Honor.
All right, so Mr. Daniels, you want to wave your right hand or raise your right hand? Don't wave it at me, just raise it. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name for the record?
Tyler Gregory Daniels.
Okay, so I'm gonna pause for 1 second. You can put your hand down. All right, so Mr. Johnson, do you have an attorney here today? No. Mr. Johnson, you don't have an attorney at this time, or do you?
It's me, Judge. Could I have a breakout with him?
Yep, I'm just gonna try to see if you guys need a breakout rooms right now while I'm taking this plea. So I'm gonna put jail Zoom number 1 and Mr. Malaro into a breakout room. And are you Mr. Cordova?
Yes, ma'am.
And who is your attorney? Do you have an attorney?
It was Underwood.
Miss Underwood, do you need a breakout room?
Yes, that would be fine, Your Honor.
So I'm gonna put Mr. Cordova and Miss Underwood into a breakout room. And I'm gonna open those now. So when you get the invitation, join the breakout room.
Thank you.
Okay. Everybody get that invitation? Just click on join. See it, Mr. Johnson? Anything to click on?
Yes,
Just use
ma'am.
the mouse. Yep, there you go. Okay, he's gone. Okay, so Mr. Daniels, so you have heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead to an added count for attempted tampering with evidence, which carries a maximum penalty of up to 2 years in prison and or a $5,000 fine, with the understanding that count 1, count 2, and count 3 would be dismissed at the time of sentencing? You would be released today on a PR bond, but your bond conditions will require that you not use any illegal controlled substances and that you test as required with Darren Coast, our pretrial services coordinator. Do you understand that?
Yes, I do, Your Honor.
All right, and Miss Adams,
All
we'll
right.
probably need Mr.
I'm sorry, but I think that Ms. Wagner and the offer was for him to plead also to an R&O as well, if I'm not mistaken.
Yes,
So
I thought the judge said that in the beginning, but
I didn't hear it, so I'm sorry. So he'd be pleading to count 3 and count 4. Count 3 being a police officer assaulting, resisting, obstructing. So Mr. Daniels, is that your understanding as well?
Yeah, and is it the same pretrial?
It's the same file. So you'd be pleading to count 3, police officer assaulting, resisting and obstructing, which is a 2-year felony that carries up to $2,000 of fines and costs. And then count 4, attempted tampering with evidence. So it would be the 2. They would run together so they don't stack. Okay.
Do you want to talk to me any further, Mr. Stewart? Or are you okay with continuing?
Can I talk to you for 1 second?
Sure. So I'm gonna open up a breakout room and I'm gonna put jail Zoom number 2.
I'm sorry, said the wrong name, didn't I?
And Mr. Murphy, you're gonna.
I apologize. I said Mr. Stewart. I meant Mr. Daniels.
It's okay.
I have 15 names in my head.
It's okay. Go ahead. Who have you been waiting on all day? Who are you waiting on? Ernest, yeah. Okay.
Judge, so pleading to count 2 or 3?
3 and 4.
Okay, thank you.
Yeah. So the count 3 is currently, but count 4 will be added.
Right, thank you, Judge.
sorry about that, Judge. I was working on the amended information and I thought that.
No, it's
thought that you
okay.
had said
It's
that,
okay.
but.
There's a lot going on today.
True.
All right, I'm gonna take these files back to Becky. Jeff, you wanna take a quick break? Okay, yeah. Thanks, Judge. And Joanne.
Hey, Matt, how you doing?
Okay. I keep telling you, you got to get a courtroom scene.
Oh, Joanne's not.
Yep. Becky, can you call Joanne?
Judge, she's not in her office. She may be taking a break.
Yeah, she might have went to the restroom, so we'll wait for her.
Should be running, right?
You're fine. All right, so Mr. Murphy. Let me see here in my breakout rooms. We need so main session. All right, so Mr. Murphy and Mr. Malaro, I understand like Ms. Underwood does the MDOC files, so she needs to go back and forth. But is there any way to have a discussion like Mr. Murphy comes to me first, or you come to me first and then go to the other court? Because I had like about an hour and 15 where you guys were all down in Judge Olsaver's, and I know you like them more than me, but
That's true.
I mean,
That's true at all.
if we could always have like maybe Mr. Malaro, you start with me in the morning, and then, you know, when you're done with me, then you go down there and vice versa. I understand the MDOC ones, but
I could do
all
that,
right, maybe
Judge.
we can-
He was at 8:15 and I thought I would get out of there quick, but
Yeah,
Judge, you
Your Honor,
are my favorite, you know that.
as I always say, I go off of what the schedule says, and it says 8:15 Judge Olsaver. If you wanted to communicate and just as long as Judge Olsaver, because again, I don't care as long as the
I'll
court's know.
talk to Judge Olsaver, because I will, and you know, 8:15 and then 8:30 are always negligible. It's not like you get them all done in 15 minutes
Yeah.
anyway, so.
I
All right,
will
I'll talk to
admonish
Judge-
Sarah and I will tell her you first.
Well, no, I'll talk to Judge Olsaver and see what he says, and I'll email you, all right?
Okay,
Okay, so we are back now with Mr. Daniels. So, Mr. Daniels, have you had a chance to speak with Mr. Murphy?
Yes, I have, Your Honor.
Okay, so do you want to plead to those two charges today?
Yes, I do.
I swore him in, didn't I, Joan? I think I did. I did swear you in, all right, Mr. Daniels? I already
Yeah.
swore you in? Yeah, okay. So do you understand that the plea agreement is you will plead to an added count for attempted tampering with evidence, which carries a maximum penalty of up to 2 years in prison or a $5,000 fine. And count 3, police officer assaulting and resisting and obstructing, which carries a maximum penalty of up to 2 years and or a $2,000 fine. The remaining counts would be dismissed. You would be released today on a PR bond, which means you'll have to report to Darren Coast in the probation department and drug test for illegal controlled substances. Do you understand that?
Yes, I do.
All right, are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, I am.
And Ms. Wagner, did you say something about misdemeanor charges, some other charges that would be not pursued on this one? Was it the spot?
I said part of the agreement is that we will not be issuing drug charges as a result of the lab reports that have come back.
Excellent. So you understand that as well, Mr. Daniels?
Yes.
Okay, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court other than the agreement that was placed on the record. Is that correct, Mr. Murphy?
Yes, Your Honor.
Is that correct, Ms. Wagner?
Yes, Your Honor.
And as far as you know, Mr. Daniels, is that correct?
Yes.
Okay, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes, I do.
Do you have any questions about the rights that I've given to you, sir?
No.
All right, so on count 3, how do you wish to plead to the charge that on or about January 29th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of police officer assaulting, resisting, and obstructing, guilty or not guilty?
Guilty.
And how do you wish to plead to the charge listed under the amended information count 4, that on or about January 29 of 24 in the city of Adrian in the county of Lenawee, that you did commit the offense of attempted tampering with the evidence, guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than the agreement placed on the record?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to plead guilty?
Yes.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
And Ms. Wagner?
No, Your Honor.
All right, Mr. Daniels, has your attorney promised you any particular sentence or estimated what your sentence will be,
No.
other than what we agreed on? Okay.
Yes.
Is it your own choice to plead guilty on these counts?
Yes.
All right, so Mr. Daniels, on January 29th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
And at that time, did you come in contact with a couple of Adrian police officers?
Oh, yes.
And for purposes of count 3, it's Adrian police officer Adrian Robinson. So did you in some way assault, resist, or obstruct him? So I guess I would ask Ms. Wagner, is this by the evidence tampering or was there another allegation?
In the process of running from the police officers, that's how the evidence tampering occurred.
Okay, so when you came in contact with these officers, Mr. Daniels, did you know they were Adrian police officers?
Yes.
They were wearing a uniform?
Yes.
And you could clearly see that they were Adrian police officers, correct?
Yep.
So at some time, did they try to get you to stop and talk to them or take you into custody?
Yes.
And did you run?
Yes, I did.
Would you agree that would be obstructing the arrest by running? Okay. Now, you also had some evidence on you, and was that controlled substance, Ms. Wagner?
Yes, Your Honor.
Okay, did you have an illegal controlled substance on your person?
Yes.
All right, so you did something to it when the police were chasing you. What'd you do? Did you throw it away? You rip it up? You throw it up in the air? You swallow it? What'd you do?
I threw it away.
Okay. And that's the basis of the tampering, Ms. Wagner?
Yes, Your Honor, if I could ask just, I think, one more follow-up question. Mr. Daniels, that you threw that evidence knowing that that would be evidence offered in a trial against you, is that right?
Yes.
Okay, thank you, Judge. I don't have anything else.
All right, has the court complied with the MCR 6.302 B, C, and D? Mr. Murphy?
Yes, Your Honor.
And Ms. Wagner?
Yes, Your Honor.
Okay. So I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the PR bond today, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. So I am going to set this matter for sentencing on May 30th at 8:15 in the morning. And I'm going to call Mr. Coast real quick.
Hello, Chair.
Mr. Coast, this is Judge Anslow. I'm on the record and I'm going to be releasing an individual named Tyler Daniels on a PR bond today.
Okay.
And then I would like you to monitor him. One of his bond conditions would be not to use any illegal controlled substances.
Okay.
And test as required, and the other not to commit any crimes. So would I tell him when he's released from the jail to report to the circuit court clerk's office and ask for you?
Absolutely.
All right, thank you.
Appreciate it. Thank you, Judge.
Bye-bye. So, Mr. Daniels, I'm gonna set sentencing for May 30th at 8:15. You're gonna be out of jail. Hopefully you're gonna stay out of jail because you're gonna behave, but, how old are you?
32.
Okay, now, Mr. Daniels, when you get released from jail today, if you get out before 4, I need you to come to the courthouse, go to the 3rd floor to the clerk's office right across from the elevator and tell them you need to speak with Darren. All right?
All right.
Darren's gonna set up the requirements for you for drug testing and also to monitor you. So you're not to use any illegal controlled substances and you're to test as required and not to commit any new crimes. Do you understand that?
I do.
All right. The second thing, do you want him to stop and get his packet today, Mr. Moore?
Yes, Your Honor.
Okay. The other thing, if you get here early today, you're going to need to go down the hall to the Circuit Court Probation Department and check in with them. And you need to give them your address, your phone number, and they'll give you a packet to fill out. You need to fill that packet out and bring it back in, and they're going to set up a time to meet with you. When you meet with them, be truthful about your background, be truthful about the events that occurred. They'll prepare a pre-sentence report. We'll provide a copy to Mr. Murphy. And then if you're out of jail, about a week before sentencing, you need to contact Mr. Murphy to go over that report with him, okay?
Okay.
If you don't get out of jail before 4 o'clock and you get out after 4:30, I need you to be back here tomorrow morning at 8 o'clock, check in at the clerk's office, see Darren Coast, and check in at the probation department as well. Okay? Do you have any questions about that?
No, I don't.
So, sentencing, do you want to appear in person or do you want to appear via Zoom?
In person.
All right, so I will mark down that it's in person. Mr. Moore, do you need to talk to him at all? I guess not. Okay. All right. So Mr. Daniels, I will see you back on May 30th at 8:15 in person. Anything else we need with Mr. Daniels?
No, Your Honor, thank you.
Nothing further from the defense, Your Honor. Thank you.
All right. All right. Thank you, Mr. Daniels, and we'll release you on a PR bond today. Stay out of trouble.
All right, thank you.
Thanks,
Thank
Mr.
you.
Daniels. You take it easy, okay?
All right, thank you, man.
Okay. So I think he's probably gonna be my last one you're here for. I'm so sorry. So let's see, Mr. Johnson. All right, so in the matter of the people of the state of Michigan versus, and Becky, you can let the jail know I'll need Ragless too. Or maybe I'll see him at 1:30, I think. I'll see him at 1:30. I'm not gonna do Ragless this morning. All right, so I have Mr. Johnson. Let me get him. This is in the matter of the people of the state of Michigan versus Troy Tavel Johnson, file number 23-21597FH. I have Salvatore Milaro appearing on behalf of Mr. Johnson. This is the date and time set for pretrial. So, Mr. Milaro, how do you want to proceed today?
And we're going to ask to adjourn this out for a short period of time and to address bond on this matter.
Okay, so May 22nd is my next available pretrial. So set this for pretrial on May 22nd at 8:30 in the morning. And if you could do the stipend order to adjourn. Ms. Wagner, can you sign your name with permission?
Yes, Judge, thank you.
All right, and Mr. Milaro, you wish to address bond?
Yes, real briefly, Judge. Mr. Johnson was, I think, picked up the end of March for testing positive. Prior to that, he had stayed in contact with me, appeared at all court appearances. He informs me that he does have a job at the company. I'm probably gonna say the name.
So, Mr. Milaro, I have a November 29th failure to appear bench warrant. And then there was a contempt hearing on April 3rd of 24. He came in, he pled not guilty, we appointed counsel. So I don't know, let me see here. Oh, and then he also, you're right. So there's two things, failure to appear. There's a contempt of court for testing positive from cocaine. He's on probation with Tom Moore. Is that correct, Mr. Moore?
Who's that?
This is Troy Johnson?
Not with myself.
Anyway, it says he tested positive for oh, maybe you just took the screen. He tested positive for cocaine on 11/29 of 23. He tested positive for methamphetamine, amphetamines, and cannabinoids on November 27th of 23, and then failed to appear. So, Mr. Malaro, I don't have time to address the bond this morning.
Okay.
But we could definitely schedule it for another time to address the bond, okay?
Yes, Your Honor.
All right, so you can just set that up with Miss Adams. So I'll set the next pretrial for May 22nd at 8:30 in the morning. And Mr. Jensen, your attorney is going to schedule in the motion for bond, okay?
Thank you, Your
All
Honor.
right, thank you. All right, Mr. Cordova. Let me get there.
I can leave.
Yep, you're all set. Thank you. Okay, this is in the matter of the people of the state of Michigan versus Araldo Augustine. And Augustine, yes?
Augustine Cordova.
Augustine Cordova. So
Yes,
this, we have file number 20-20113 FH, 21-20245 FH, 21-20680 FH. These are violation of probations, and Ms. Underwood, you were appointed to represent him on these files. So, Ms. Underwood, how do you want to proceed today?
Your Honor, the problem is this matter is involved with a district court case that Mr. Cordova has, where he is pursuing his rights, and so he can make no statements about that case. And that case is not close to being resolved, is my understanding. I would ask the court to consider adjourning this matter. However, I would ask the court to consider, Mr. Cordova, I understand, has $100 bond downstairs, Your Honor. That's what he informed me. And I would ask the court to consider that and either give him a PR with reporting provisions to Mr. Coast or match that $100 bond, Your Honor, to allow him to pursue the case downstairs. And in turn, that would lead to some sort of resolution up here.
So he has several cases here, a 4-year felony, a 10-year felony, and I think the other one's a 4-year felony. He's on probation with Jen Walsh. I don't know if you can communicate with her, Mr. Moore. The allegations on the violation of probation is that he assaulted a Taylor Garza, failed to complete a drug test, and then engaged in assaultive, abusive, threatening, or intimidating behavior on January 31, which obviously is the new charges that you're referencing. Mr. Moore, does Ms. Walsh have a position on reducing bond here?
No, well, he's absconded over a year. So
Yeah.
she was looking at incarceration with them. So at this point, I don't see any reason for a bond because it.
And Ms. Underwood, in light of the fact that he's absconded from bond for over 12 months, I'm not going to lower or set a bond like that.
Thank you, Your Honor.
All right, thank you. All right, so what I will do is I will set this, when's his next court date, Ms. Underwood, downstairs?
Let me check.
When's your next court date, Mr. Cordova?
I got a settlement for the 28th of May, and then I got jury trial set up for the 5th of June.
5th of June. So why don't I set this? Here's what I'll do, Ms. Underwood. I'm going to set this over to June 26 at 8:30 for a pretrial. If that case downstairs gets resolved, you can bring him in sooner. I won't be here for like 2 weeks, but Mr. or Judge Olsaver can take a plea up here if you want to move it along faster with that case down there. But I'm going to set it for June 26.
Thank you, Your Honor.
And then obviously if the case downstairs gets resolved and he wants to do something up here, you can get him back in sooner. Just know mid-June, you'll have to do it in front of Judge Olsaver, all right?
Thank you.
All right, so we'll see you back then, if not sooner, okay, Mr. Cordova? Okay, you can do this, we'll do the notice because it's Bob. All right, so we are down to Mr. and Miss Underwood. I can't do Mr. Raglis this morning, so I'm gonna call his case this afternoon. What time would that be good for you? That's the Bob pickup.
I have a case downstairs at 1, so I suppose probably 1:30.
Okay, we'll bring him back at 1:30 then, Miss Underwood. We'll wait for you. Thank you.
Thank you. I believe that concludes everything else.
Yeah. Okay, so this is in the matter of the people of the state of Michigan versus Ernest VT Jasper. We have file number 23-21587FH. And then we have matter of the people of the state of Michigan versus Ernest VT Thomas, formerly known as Jasper. File number 24-21778FH. Mr. Murphy, you're on this file. So I have Matt Murphy appearing on behalf of Mr. Jasper and Thomas. So Mr. Murphy, how would you like to proceed today?
Your Honor, on file 24-21778FH, we're here for an arraignment. In regards to that matter, we acknowledge receipt of the information and the witness list and the discovery demand from the prosecution in that file. We waive a reading of those information in open court. In this matter, Mr. Jasper has been determined to be competent to stand trial by the Forensic Center, but we are waiting for them to do an evaluation of criminal responsibility. I don't know if the court has in its file the 23-21587 any update from the Forensic Center. The last thing I have from the Forensic Center was actually in regards to Mr. Jasper or Mr. Thomas being down in district court. It was dated.
Okay. Are you just asking me to enter a plea of not guilty instead of pretrial in that file?
Yes, Your Honor. I'm just not sure if the court knows how long it's going to take because this was done March 21st and it said it'll be 60 days still until they finish it.
So something the end of May would be all right?
I believe so, Your Honor.
All right, so I will enter a plea of not guilty on behalf of him on the file set for arraignment, which is 24-21778FH. And then I will set a pretrial on both files for, let's do, you want May 29 or June 5 to give him that extra week to mail it out?
I think May 29th was what I would ask for. Hopefully it could be done by then.
So I will set this over for both on a pretrial on May 29 at 8:30 in the morning. And then we'll do the notice of hearing on the arraignment file. And Mr. Murphy, you need to do the notice of hearing on the pretrial file. And
Yes,
his
Your Honor.
bond is continued. So Mr. Jasper, we'll see you back then. If the report comes in sooner than that, Mr. Murphy will schedule with my court to get you in sooner, okay?
Your Honor, could I can I take a few minutes just to talk to Mr. Jasper in a breakout if you don't have anything else going on?
That's fine, but I will do that. So hold on.
Thank you.
Mr. Jasper, your attorney wants to talk to you, so I'm gonna put you guys in a breakout room. And then when you're done, you're all set, okay? All right, so I'm looking through the docket and it appears that we have called every single case. So that will conclude our criminal docket. And I will do the Raglis pickup at 1:30. All right, so
Thank you, Judge.
Mr. Jasper, you gotta click join. Go ahead and join that breakout room. And we're all set. That's it. Sorry. Now, Miss Adams, are you?